Okay, I was talking to you about different ways of overturning a wrongful conviction, having a case expunged, revoked, reversed. Okay, but let's talk about wrongful conviction compensation. As of 2024, 35 states, Washington, D.C., and the federal government have laws to compensate people wrongly convicted. Federal law awards $50,000 per year, which is really lowballing for wrongful incarceration up to a maximum of $2 million. Most states also provide $50,000 or more per year. Some states like Texas offer additional compensation such as lifetime annuities, job training, and medical treatment. Compensated may be reduced if the exoneree has prior felony convictions. Okay, how much money do you get if you are wrongly convicted? If wrongly imprisoned, you can get compensation, but varies by state by state federal law, typically around $50,000 per year of incarceration, plus extra for death row time, plus non-monetary benefits like tuition, housing, and legal aid. Through some states offer lump sums or have different formulas. The federal standard is $50,000 annually, but states like Texas offer more, $80,000. Okay, how much money per day do you get wrongful conviction? There's no single day rate. Um, what is the largest settlement for a wrongful conviction? 2.5 million. False imprisonment. Okay, so so you can. So if you go through any of my other videos, I tell you how to overturn a wrongful conviction. Okay, let's go. See, this is an easy way to turn your case over, because a lot of these in criminal court are denied a quick and speedy trial, and you don't even know the framework for a quick and speedy trial, the limitations on a quick and speedy trial. So if you have been denied a quick and speedy trial, people, seriously, research this. If you're locked up, know somebody that's locked up, know somebody that's doing time. Anybody, they could be sitting on death row. A speedy trial is a constitutional right under the Sixth Amendment, ensuring criminal defendants are tried within reasonable time, generally within 70 to 100 days for federal cases, to prevent prolonged unjust incarceration. The rights prevent excessive pretrial detention, reduces anxiety for the accused, and ensures evidence remains fresh. Key aspects of a quick and speedy trial. Constitutional basis, Sixth Amendment guarantees a speedy trial to prevent indefinite deterrent. Federal Limits Speedy Trial Act of 1974 mandates the federal trial begin within 70 days of indictment or appearance, with specific exclusions for delays. Becker versus Wingo factors courts use fourth part balancing test to determine if the delay is unconstitutional, length of delay, reasons for delay, defendant's assertion to the right, and prejudice to the defendant. Consequences of violation. It's the right violated. The case may be dismissed potentially with prejudice, meaning it cannot be refiled. Okay, consequences of violation. Okay, so if you've been denied a quick and speedy trial, if the right is violated, the case may be dismissed potentially with prejudice, meaning it cannot be refiled. Basically, it would be violating the double jeopardy clause. You cannot try a person twice for the same crime. Strategic consideration. While it protects the innocent, some defendants may choose to waive their right to allow for more time for the defense participation. See, but a lot of y'all didn't know that you were entitled to a quick and speedy trial, And it happened to me where I go to court, and usually you get the public pretender, and the first thing they tell you is sign this and you can go. That's ineffective assistance of counsel in its entirety. That's deprivation of rights. Okay, so you don't take it, and they get mad because I advise a lot of people to, hey, you should ask for a probable cause hearing because there was no probable cause for arrest. And the public defender gets mad and goes and tells the state's attorney and the judge. It comes back and tells you, or as they told me, if you don't take this, state's attorney's going to double up on the charges, bring more charges against you. So you say no, and they just keep adding on charges to revoke you, the public pretender, and the state's attorney, the official state's persecutor. And they'll tell you, the judge don't like you not taking the cop out. Just take the cop out. If you don't take the cop out, you try for a jury trial. The judges give you more time, if you lose in a jury trial. So it's just it's an intimidation game, okay? So your lawyer's not telling you the limitations of a quick and speedy trial. State's attorney isn't telling you the limits of a quick and speedy trial. The judge isn't telling you the limits of a quick and speedy trial. Your lawyer isn't even demanding a quick and speedy trial. I've seen people go at it with the public defender and the judge prolong the case. The last time I went to court, before this handicap thing kicked in, I went to court to help this kid, and they spent 9 months trying to get this kid to cop out. And then finally they threw it out. Motion to quash. And so this kid I've been trying to tell him, you didn't have a quick and speedy trial. That case should have been thrown out after a couple of months, but no, they spent a year trying to convince you just to take the deal, take the plea. It was a gift we were giving you in the very beginning, but it turns out, might as well be getting that delivery from the Unabomber. Okay, but you can actually have a wrongful conviction squashed simply because you didn't get a quick and speedy trial. Remember, it says down here, consequences if the right is violated, the case may be dismissed potentially with prejudice. Now you got to ask the judge when they dismiss this case, to vacate with prejudice. So that way they can't refile. Because they will try to refile. They will try to violate your double jeopardy clause. Because, see, there's a lot of stuff. If you don't know it, nobody's going to mention it. That's a complete denial. That's conspiracy against rights under the color of law. Your constitutional rights are supposed to be guaranteed, but if you don't know them, you're not going to get them, and everybody's keeping that stuff secret from you in that courtroom. And that's disinformation. They say, well, we didn't say nothing. Well, in a court of law, not saying anything is lying. Withholding information. Okay, so if you want to get your case out of court real quick, one of the easiest methods is a quick and speedy trial. They have no reason for delay, especially with you guys that took the plea deals. If you took a plea deal, you can say it was under duress because you didn't know that they denied you a quick and speedy trial. They kept you in jail, and then use the Eighth Amendment, about the bonds they give you. You can't afford that. That's why you were stuck and you wound up sitting in county lockup for 8 months. And they kept telling you to sign this, and if you sign this, you can go. And then you sign it so you can go, and you wind up leaving there with a felony because, you were put under duress. You were denied a quick and speedy trial that you had a right to, but you didn't know about it. Nobody mentioned it to you. Nobody offered it to you. So it's supposed to start with your lawyer. So that's deprivation of rights. State's attorney and the judge are supposed to make sure your lawyer brings this up, and he didn't. So that's deprivation of rights on both of their behalfs. And since nobody brought it up and nobody reported your attorney for ineffective assistance of counsel, because that's misconduct, reporting misconduct is mandatory in the rules of professional conduct and the code of judicial conduct. So neither the judge or the state's attorney brought it up, which creates a conspiracy against rights under the color of law. So you can not only file for the failure to give you a quick and speedy trial, but their failure to do that and even offer it is a conspiracy against rights under the color of law, which is against federal law. Okay, people? There's a lot of different ways you can do it. Okay, you can throw this on the motion to quash, okay? You can mention that in the motion to quash. What was that one? Ineffective assistance to counsel motion. IAC motion. You can also file with, you just type in rules of professional conduct complaint form to file against your attorney, code of judicial conduct complaint form to file against the judge. And then I have an easy out on one of my posts. Okay, let's go there really quick. Sorry. You could throw, there's not much language you need when you throw it on your conspiracy against the color of law complaints, a conspiracy against rights under the color of law. There's so many laws they break, to petition the Supreme Court to overturn wrongful conviction, you can use that too. That's where conspiracy against rights under the color of law led to conspiracy to commit murder. That was what they did to me. Because I knew this stuff and I was throwing it around in court. And I arrogantly said it to my lawyer before I got out there to speak to the judge, and they didn't allow me back in court and walked me through the tombs. Got back to Division 1 in Cook County Jail, and that's where they beat me and left me for dead.
Often I've had people get upset with me when I state something and say, you can kick rocks if you don't.
You can see I talk a lot about all the laws they break. Okay, let's see, I think this is it. Okay, this is it. Okay, some people made the mistake, they stated a whole bunch of stuff before this is what you put first, okay? No matter what complaint you make, and no matter what your complaint is based on, start here first, a conspiracy against rights under the color of law. That's going to be your opening, okay? Because all that evidence and everything that happened in court, that's just icing on the cake. And that's a whole lot of icing. You wind up with more icing than you do cake. So let's deal with the cake first, okay? This is what you want to say first. Okay, when you file for conspiracy against rights under the color of law with the DOJ, the FBI, whoever, okay, if you file a motion to quash, if you're filing with the Supreme Court, no matter no matter what case it is, child court, criminal court, it doesn't matter, because none of this happens in a court of law. Okay, so this is what you're going to want to use. Okay, this is short and simple. A conspiracy against rights under the color of law. The judge failed to report my counsel and the opposing party for multiple counts of misconduct and themselves for judicial misconduct. The opposing party failed to report the judge for judicial misconduct, my counselor for ineffective assistance of counsel, and themselves for misconduct. My counsel failed to report the judge for judicial misconduct, the opposing party for misconduct, and themselves for ineffective assistance of counsel. Reporting misconduct is mandatory in both the Rules of Professional Conduct, the Code of Judicial Conduct. Failure to report misconduct, just as well as failure to enforce one's constitutional duties as prescribed Rules of Code. The lack of requirements of the Sixth Amendment of the U.S. Constitution is beyond ethical. The lack of effective assistance of counsel doesn't allow for a fair trial, which shows due process didn't exist, a deprivation of rights in its entirety. This clearly shows the judge and attorneys in my case committed a conspiracy against rights under the color of law, which prohibits the willful deprivation of rights, no immunities under the color of law. Prohibits conspiracies to injure, oppress, threaten, or intimidate any person in the free exercise, enjoyment of any right or privilege secured by the Constitution or laws of the United States. I trust you will live up to the oath. You know what the penalties are for violating the oath, right? And show, now I'm using the rules of professional conduct to push them to do their job. Okay, I trust you will live up to the oath and show competence, diligence, and in expediting litigation, as I have meritorious claims of contention. So I strongly stress reporting professional misconduct, the integrity of in maintaining the integrity of the profession. Communications will be made for ethical violations, and every penalty will be imposed. In the public interest, as trustees, this is how to maintain the public trust. Failure to do so will add to this conspiracy against rights under the color of law. That's all you got to put. And when I start with the canons down here, that's just what they didn't do. You know, a judge shall perform the duties of judicial impartiality competently and diligently. They didn't do that. You know, that's why you didn't get a quick and speedy trial. That's why you didn't have effective assistance counsel. That's why you had prosecutorial misconduct and judicial misconduct. If you read the rules of professional conduct and the code of judicial conduct, you'll see none of that was done. And that's what this is based on. See, so the judge didn't give me my right to be heard, ensuring the right to be heard by denying me that. Then look how many laws, you know, a judge shall perform their duties, partiality, competent, diligently, responding to judicial and lawyer misconduct. See, my lawyer went and told the judge I was going to demand she report my lawyer herself and the state's attorney. Demand everybody report each other, because reporting misconduct is mandatory in the rules and the codes. That's what I told the judge, my lawyer. I was pissed. Fuck you, excuse the language, fuck you, fuck the judge, fuck the state's attorney. I didn't mean to go, but it just didn't. Even though I was demanding my rights in the court of law, the crazy-ass stenographer wasn't typing stuff that I was saying, other people, the judge or the lawyers were saying. They limited what they put on the court record. Sorry, there's no video to prove that, but I know of people that have videos showing the stenographer. At least one gentleman told me he taped it, and then he got the court reports, the transcripts, and the transcripts were missing a lot what was in the recording, which is crazy. But see, once the judge breaks one canon, then here's a whole list of all the other canons that she broke, which I cited with the Judicial Inquiry Board, but they never answered me. See, so this is all the stuff the judge didn't do. So that's what that little bit up there is saying. There's a lot of stuff the judge didn't do. You can't violate one canon without violating multiple canons, multiple rules in the canons. See? So there's a lot of stuff. When I filed with the ARDC, nobody cooperated with the ARDC or the Judicial Inquiry Board. Actually, the Judicial Inquiry Board blew me off. I finally got a reply from them. I've been doing it for years, and they finally got a reply somewhere in the 90s. They told me, get a lawyer. See, now this is just the Code of Judicial Conduct, because the judge didn't allow me My right to be heard. Look at all this other stuff I could hold that judge for. It's impossible to violate one canon without him violating the others and so much other stuff. See, so all this stuff didn't happen. And then I'm telling them, well, you got to report the lawyer, and then you got to report the lawyer for everything they didn't do. And because they didn't do it, see, that's when I got down here. So they're supposed to report the lawyers for failure to be competent, scope of representation, failure to be diligent, no communication. How could they even charge a fee when they weren't doing their job? Confidentiality of information. When your lawyer runs to the state's attorney and the judge and tells them you don't want to take the deal, you won't sign the papers, you won't take the cop out, you won't take the plea. That pisses off a judge pretty much. You can ask any of them. And your lawyer will tell you, hey, if you take a jury trial instead of a bench trial and you lose, the judge will give you more time. Which, ask the judge. Ask the judge. Is that true, Your Honor? He told me if I take a jury trial over a bench trial, you don't like bench trials. You get mad because I can't trust you. Okay, meritorious claims and contentions. A lot of people come to court. That's why I always demand a probable cause hearing, because they always lack meritorious claims and contentions. They must have that before anything can proceed in court. So the state's attorney knows that. They're supposed to check, but they know the public defender don't give a damn about you. They're just going to sign this paper, and you can leave here with a felony. We're going to get you 3 times, and after you leave, we're going to arrest you for being a 3-time loser, the 3 strikes law. Oh, man. Expediting litigation. That's why you didn't get a quick and speedy trial, because nobody expedited the litigation. Candor Torch Tribunal. Did anybody mention violating limitations, the statute of limitations on the quick and speedy trial? They only have so much time, and they didn't do it. Fairness to the opposing party and counsel. When I talked to the state's attorney about my lawyer being an effective assistance counsel, she said that's between you and your lawyer. No, fairness to the opposing party and counsel is to report misconduct as says right here, 8.4, misconduct. And then 8.3, reporting professional misconduct. Damn, nobody does any of this, okay? So you got a lot to work with to have your case exonerated. I wouldn't say expunge. You don't want to expunge the record. You want to overturn the record. So go for the exoneration. You got a lot of info here, a lot of ammunition. Okay, you don't even need evidence. You just need the damn law. See all this? So that little bit up there says a whole lot right here. Conspiracy against rights under the color of law. Okay, so that's what you're going to do. Copy it from here, from there, right down to there. You can stop where it says Canon 2. Because when you do it on the internet, DOJ, they wanted 500 words or less. But when you put it on paper and you send it in yourself, oh man, you can get downright dirty and nasty and throw all this at them, okay? And then when you get down here to where what they're supposed to report, everything that was violated in the rules of professional conduct, this is just the preamble. So lawyers didn't do nothing in the preamble of the rules of professional conduct. And then here's all the rules they violated. Okay, so have fun. Listen. You're a lot smarter than you think. I know it. I test every one of you that I talk to. Just because you didn't know this before I spoke to you didn't mean you couldn't know it after I did. People told me I'm smart. But if I'm that smart, wouldn't you be just as smart if you read all this stuff I read? All this stuff I post about? I mean, you can know this too. I'm nobody special. I'm just somebody that has to know. Felt the need to know. You know how many times I was told I didn't need to know? Okay, but you can know too. You can know just as much as I can. And my time is coming to an end, so you could probably know a whole lot more by the time your life ends. I made a promise that I would teach as many as possible before I leave this earth. I don't have monetary wealth to leave behind. I spent so much time doing this, kept me broke. But I have a wealth of knowledge to give to you. But I can't just give it to you. You got to come here and take it. It's yours for the taking. And it's for free. People offer me money to help them, and that's ridiculous. I don't ask for money. I don't take donations. There are no fees. As a United States citizen, I grew up in school saying the Pledge of Allegiance, and I took that seriously, especially after I read the Constitution, Declaration of Independence, took me to the Magna Carta, the history of the rule of law. So I always took the Pledge of Allegiance seriously. And when I pledged allegiance, it wasn't to a politician, a political party, the government. It was to we, the people. That's where my allegiances, my loyalties lie. As that should of every public servant. I am not a public servant, but I am of public service. This is what legal reform is about. Teaching you what you need to know. Okay? What nobody's telling you. I'm not giving you legal advice. I'm just showing you the law. It's up to you whether or not you want to use it. All you got to do is read it. It all makes sense. It all made sense to me. I put this together after reading the rules of professional conduct and the code of judicial conduct. It was that easy, and that was in 1979. I found the rules. It took me to the codes. They're symbiotic. They're intertwined. You cannot violate the rules without violating the codes. You cannot violate the codes without violating the rules, because the only way anybody can violate the rules of professional conduct is because their job title of the Code of Judicial Conduct judges allow it. The only way a lawyer can violate the rules of professional conduct is if the opposing party and the judge allows it. The only way a judge can violate the Code of Judicial Conduct is because the lawyers allow it. And they all allow it. Nobody reports anybody for violating the rules or the codes. All right, people, I'm sorry. I don't mean to sound like I'm lecturing, but again, I am. But I'm doing to you what I've done to so many others, showing you who you are. Reverend Jesse Jackson was famous for saying, "I am somebody." Well, you got to tell you that. I am somebody. I am we the people. I am those you took the oath to serve and protect. You know what the penalties are violating the oath, right? Look it up. It's on the net. I also did a video on it. Nothing but peace and love to one and all. May your Creator always be with you and rain many blessings, long life, and good health, my friends. I hope you're listening. I hope you understand. And remember to hold everybody to the letter of the law. You know what the penalties are for violating the letter of the law? Look it up. It's on the internet. I also did a video on that, too. Okay, penalties for violating the letter of the law are fines, removal from public service, and incarceration. If death is involved, one can also receive the death penalty. Okay, pretty easy. But the letter of the law requires all of this to be done word for word to the letter. In the spirit of the law, so we can all see, say, and hear the same thing. Good night, everybody.